Today we're going to be covering the basics of seeking a guardianship for a disabled adult. The legal standard for obtaining a guardianship has to do with whether there is a person over the age of 18 who is unable to make or communicate responsible decisions. That could be as a result of a physical disability, a mental illness, or less commonly, a problem with alcoholism, drug dependence, debauchery, or idleness. In this case, the standard is not whether or not you would agree with all the decisions that the person makes, but whether they have the capacity to make a responsible decision. Under Illinois law, in order to serve as a guardian, a person must be a United States resident over the age of 18 who has not been adjudicated incompetent. Usually, the person should not be convicted of a felony, although that would be allowed in some exceptional cases. That would be, for example, if there had been a felony conviction a long time ago, person had shown that they were rehabilitated, and the offense for which they were convicted was not one where there would be an absolute exclusion. That would be, say, for instance, abuse of a person with disabilities or for a child. There are specific offenses which are listed in the statute.
And I've had instances where we had a proposed guardian who was the mother of the individual, and she had some financial issues in her past. And so she was not approved as guardian of the estate because of her felonies, but was approved as guardian of the person. And we're going to talk about that there are two different types of guardianship. But when you talk about who may serve, you can also be thinking about that people can serve as co-guardians. So if there is an individual who maybe would do better having the assistance of someone else serving with them, or it makes sense for whatever the family dynamic is, you may have more than one guardian in place.
Sometimes you have two half guardians that together will make a whole guardian. Sometimes there are snowbirds, or somebody is not going to be able to be engaged for part of the time, and they'll need somebody to back them up. Sometimes this is a good idea as succession planning, that if, say, for instance, you have older guardians, then you may want to have a younger person as co-guardian if they work together well. Then they're going to get some experience so that they're going to be ready to move into the primary responsibility at some point and learn the job as they go. And sometimes, because of family dynamics, that's going to be desirable as the way to handle it.
The other thing to think about is how you want your order to read if you're going to have co-guardians. I usually err on the side of having my language say that either guardian may make independent decisions, so that if there is a medical emergency, the hospital isn't trying to get both guardians' approval to get something done. But depending on the dynamics in your case, it may be that you really do want it to be the order to require both guardians to sign off on whatever that decision may be. And so you need to be careful as you craft your order to pick the way you want it to be. The other thing is that corporations, think banks, can be guardians of the estate. And when they talk about public agencies, there is the Office of State Guardian. So if there are no family or friends who can serve, and we have a public guardian in Champaign County right now, that's John Brown, who can be appointed by the court. And the difference between Office of State Guardian being appointed and the public guardian has to do with whether or not the individual has any funds. And if they have no money, then they're going to be Office of State Guardian.
If you're considering the Office of State Guardian, they would like for you to let them know and to provide them with the information that they need to determine that they really are the last resort and they have to do another one. But
yeah, they have an intake form and an intake office out of Hines, Illinois. and you need to make sure that you're in contact with them, you fill out their paperwork, and you get everything to them. We used to have local lawyers who would come to our hearings. We no longer have anybody locally, so they generally don't show up at the hearing. But they will provide you with an oath and bond and basically an acceptance of office prior to your hearing if you get in touch with them ahead of time. So the different types of guardianship, you've got temporary or permanent. So the difference in the statute is that with a permanent guardianship, you have to have at least 14 days notice. You send out a summons that gets served upon the individual you're seeking guardianship over. And that's for as long a duration as you need. Those hearings are, by statute, supposed to be held within 30 days. On a temporary guardianship, the notice is whatever notice the court deems appropriate. So if you have a medical emergency and you need to get into court quickly, the judge will have to approve that you are going to have a shorter notice period, and then the temporary guardianship is good for 60 days. In Champaign County, the procedure is still to serve the individual with summons. So even if you're serving them that morning for an afternoon hearing, you need to try to get that done. I don't know if anybody else here has had the experience where they haven't had to serve a summons. I know some counties don't require it for a temporary. My experience in Champaign County is you do. So then there's the guardianship of the person and the guardianship of the estate. You want to talk about
Sure.
that a little bit?
Guardianship of the person would primarily that would be for medical decisions about where the ward will live. The significant decision that would require court approval would be residential placement. And so that, say for instance, would be a nursing home. It should be the least restrictive appropriate placement. And sometimes there is some discussion of that issue about what the appropriate placement would be. And with some kind of involuntary mental health treatment, there is case law that says in that case you have to go through the mental health code, that using the probate act in a case like that would not be the appropriate vehicle. And in that case you have to prove a completely different set of things. You have to show that somebody is a danger to themselves or to others, and it could be more difficult to do.
So it's really a separate path. A lot of times, I shouldn't say a lot of times, I have had cases where people come to me because there is an individual with mental health issues and they want a guardianship. And the guardianship is great because it helps the family be able to have access to medical records and to know what's going on, because any of you who are familiar with the mental health code know that if you were to call, the 5th floor at Provena and somebody is there, if they haven't consented to you knowing that they are there, all the facility can say is, we're sorry, we can't confirm or deny if they're here. If you are their guardian and they have a continuing mental health issue, when you call, they now have to talk to you. You now get to know that your son is on the 5th floor and is receiving mental health treatment. You also get to know what's going on with their medications. The issue is that as a guardian, you can't consent to involuntary treatment or involuntary medication. So it only gets you part of the way. And so it's important to be clear with those clients who expect that guardianship is going to fix everything, that when there's a mental health issue involved, sometimes they're going to have to go the route of going to the mental health court as well. And then guardianship can also be limited in scope.
This is in the statute as something which is preferred, but it is underutilized. The difficulty is that if you're going to have a limited guardianship, you don't know what the course is going to be with a degenerative process. A lot of times you'll think that sooner or later you would need plenary authority. If you're going with a limited guardianship, there need to be enumerated powers that the guardian would have. And this certainly may be appropriate in some cases, for instance, where a disabled person can handle small amounts of money, but not big amounts of money, or where there are some things that they can handle and some things that they can't handle.
The most I have used this for is to allow for driver's licenses. Because once you are adjudged a disabled adult, that information goes to the Secretary of State's office and your driver's license is suspended. And depending on the reason for the guardianship, there are times when somebody could still have a driver's license. What I usually do is have the doctor and the medical report, and we'll be talking about the medical report, specifically delineate that a driver's license remains appropriate for the individual, and then I would limit the guardianship so that they can continue to have their driver's license. So the ethics of this, many of us do estate planning, or we have clients that we've had for a long period of time. And what happens when your elderly client becomes somebody who now needs a guardian? And what are the ethics of you being the attorney for that elderly client who now may be being financially abused or even physically abused? And can you reveal information about your client's capacity? So we have a rule of professional responsibility directly relating to this. And this is a fairly recent change that allows lawyers to reveal what they need to reveal in order to protect their client's interest, and to actually move forward and seek guardianship if that's necessary to protect their client. I can tell you from my experience, I would not be comfortable seeking a guardianship over an existing client. What I would do is call one of you and say, I'm referring client X's kids to you because they need to talk to somebody about guardianship of mom. And let somebody else take that case, because ultimately the person you're seeking guardianship over is entitled to an attorney. And if you've been their attorney for a long time, they're likely to call you and ask you to step into the case. And they need to have someone who's representing them as well.
In our office, we always represent the petitioner in the guardianship if we are seeking to establish a guardianship. I think that that clarifies some of those issues, but we would consider conflict of interest before we get involved. And although it's not used very often, a disabled person or an alleged disabled person can petition for a guardianship themselves. This accounts for about 15% of the filings in Florida, but very few of them here in Illinois. But there may be some people that have the capacity to understand that they need some help, and there's somebody that they want to help them, and they want, for whatever reason, a guardianship instead of a power of attorney, perhaps to provide additional oversight or have a more formal arrangement.
So this is a long list of the steps that I go through, and I think John goes through, when we have an initial client come in and say that they would like to have a guardianship over an individual for whatever reason. I have an initial letter that I send out gathering information, and I don't think the letter is included, but my intake form is like the top page of what you have on your table, because that's the information that you need to even move forward with starting with a guardianship. So you need to know, what the medical issues are, whether the individuals who are seeking to be guardian actually meet the statutory requirements, and you need to sit down and talk to them about what's going on. My goal is always to avoid court if there's a path to do that. So could we refer the individual you're seeking guardianship over to their own attorney to do a power of attorney? Do they have capacity to do that? Is there something going on here where having a family meeting might make it better? If those kinds of things aren't going to make a difference, then you need to start moving down the process for a guardianship. And so The next step in the process is to get a medical report.
And it's important to do that early on because the medical report can go stale. It's supposed to be based on an evaluation which is done within 90 days of the date of the hearing. So if you're having problems getting the medical report and you already have your petition on file, you've probably got things mixed up in terms of the order. And the medical report may also provide additional insight about where you go with the rest of the case, because you'll have a medical professional giving you some idea about what they believe are the parameters of this person's ability and the underlying causes.
The other thing is, your clients may believe that mom really needs a guardian, but they are not medical professionals, or maybe they've seen a decline that to them is significant, but it's not legally meeting the standard. Until you have the medical report, you're not sure. You can file a petition and request a court order to get a medical report. So if you have someone who's unwilling to go to the doctor to be seen, you can file a motion and request that the court order them to do that. You've got to have at least someone, though, who's willing to say that they believe a guardianship is needed. So, a family member or a friend or, an agency that's willing to say that. With respect to the medical report, I always file a motion to seal, and I'll give Andrew Beckett credit for that. He's the one who suggested it, and I follow his advice on that. The statute does say that the medical report is not a public record, so even if you don't do a motion to seal, it technically is supposed to be sealed within the court file, but I just think it's good practice to get that done.
As far as getting the medical report completed by a doctor, I'll just say a couple things about that. One of the people that signs the report has to be a licensed Illinois physician. And a lot of people these days are seeing other health professionals, like a licensed practicing nurse or a doctor's assistant. There are a number of different people that may be able to prescribe and see patients, but they're not physicians. So in that case, usually what I do is I have a letter that I send to the doctors or the person who's treating them, which explains what we need to do under the statute and what's necessary in order for it to qualify. That will help alert me to problems such as they haven't seen this person within the appropriate time frame, or if the person who would be able to sign the evaluation needs to have it countersigned by an Illinois physician, that we get all the necessary signatures on the document. Usually I have found with a letter explaining what I'm doing that I don't have a problem getting the medical report. I know that there can be HIPAA issues, but there is an exception within HIPAA if there is some danger that the person is in, so the medical information is necessary. I haven't had too many times where there was trouble getting it.
I haven't either. There's also a medical report form in your packet, and it's statutory, so you just need to pull it out of the statute and have your physician fill it out. Venue is proper in the court, in the county where the respondent resides, and if they're not from the state where their real or person or estate is located. So if they have a bank account, but they're from out of state, you can get it here. I would say though, locally, if we have somebody who's hospitalized locally, even if they're from another county, if they're not going to be able to travel to a hearing, if they're in Vermillion, that's where they live, but they're in the hospital in Champaign, our judges will generally hear the case. It may eventually end up getting transferred back, but particularly on temporary guardianships where there's an emergency present, they recognize that we need to get somebody in place as a decision maker.
Deb, and John, when
Yeah.
somebody is under a guardianship property in the venue of Champaign County, and then they're moved for some some reason, what is the kind of limits and rules on how fast the guardianship has to be transferred or whether it does?
In my opinion is it does not have to be, but you have to be prepared to continue to report to the Champaign County Court. And so as people move further and further away, it becomes harder to get them to come back for that reporting. And at that point, I usually recommend that they move it to either the county where they're at, if it's state of Illinois, or I've done them where we've actually enrolled them, gotten the court order to transfer venue and moved it to another state.
There is a procedure for transferring guardianships from one state to another and also transferring from one county to another. It's kind of tough to get one out of Cook County, but I think it has to do with distance as far as what's going to be most practical. I think it would be difficult for somebody to have to travel a long way to appear for reports and things like that.
It also makes it hard for the guardian ad litem. So the guardian ad litem gets assigned to make sure that things are happening in the best interest of the ward. And if the ward is, living in another state, it becomes increasingly difficult to keep tabs on what's going
But
on.
it's not mandatory, once the court has jurisdiction and takes the guardianship, it's not mandatory?
Correct. At least I don't know anything in the law which makes it mandatory. So with respect to assessing costs, if you do them for John, there's no costs.
Well, yeah, and not every county has followed this protocol, but in Champaign County, where we have a fee waiver, the court has, in appropriate case, been assessing fees to the county. That's something that probably would vary from place to place. I know in the Guardian ad litem statute there's the fee waiver statute makes reference to guardian ad litem fees as one of the things the waiver would cover. There's actually two fee waiver statutes that aren't exactly the same. So I think that I've also found in some counties that the local bar is very generous with donating their time to these cases where they know that our clients don't have a lot. And I'm grateful for everybody who has been willing to do that. A lot of those people I see right here. I thank them every time.
I always warn my petitioners, the statute says that costs can be assessed against the petitioner. Now, oftentimes what we do is once the guardianship is in place, we do a petition for fees and costs, and we request that the person that we sought guardianship for, that their estate pay for it, because they're the one who truly benefited, not the petitioner who was willing to step up and help, but the person who actually needed help. But the statute allows the fees to be assessed against the petitioner. So people who are going into this need to understand that they could be on the hook for all of the costs and fees that are associated with the file. Additionally, they would get guardian ad litem fees, or if there's a court-appointed attorney, those fees could be assessed. And then I just have a note about financial affidavit. If you are going to seek to have the fees waived, unless you've got the Land of Lincoln waiver, you need to have a financial affidavit on file with the court. So what are the petition requirements if you want to go ahead and file for guardianship? So this is kind of the list of what you need to have in your petition, and it's in the statute, and it's pretty clear. But you need to make sure that you go through and you hit all of the things that the statute requires. You need to tell us who the petitioner is, the name of the respondent, the reason for the guardianship. You need to disclose if there are powers of attorney. Sometimes the agents under the power of attorney are not who is seeking guardianship. Sometimes people are seeking guardianship specifically to remove the agents, and you need to make that clear and attach copies. You got to provide addresses and notice to the nearest relatives. You need to also provide information about financials so that the court knows whether a guardian of the estate is necessary.
Just as far as the nearest relatives, the statute specifically lists quite a few of them. Now, it used to be that you would go in order and it would be just the spouse if they had a spouse, and then you go down the line. Now, you have to give notice to the spouse and adult children, parents, and adult brothers and sisters. For some people, this is quite an intimidating list of people. But in that case, you do the best job that you can with coming up with the information to locate everybody on the list, and that may sometimes take a little bit of research. There is case law that says that if there is a relative that should have been given notice and they don't get it, that could subject your case to collateral attack if they don't otherwise have actual knowledge or something about the hearing. And in some cases, I've found out about a relative I didn't know about, sometimes even at the hearing. And sometimes in those cases, judge will allow that to be cured by having an appearance and consent filed by that person. If you really can't find somebody, I've seen differing approaches from the court about what you need to do there. In some cases, just saying that their address is unknown would be sufficient. Some judges may want you to do more.
And I have found that if it is someone who has just turned 18 and you can't find one of the parents, sometimes the judge will require that we publish. But if it's somebody who is more elderly and you can't find someone, they tend to allow the address unknown. And sometimes the people that you're seeking guardianship over aren't the best reporters. And so it can be really hard to track down family members. You've just got to do the best job that you can.
Do all the same family members that receive the notice of the guardianship have a right to the annual reporting?
I always send it to them unless the judge has ordered differently. I think there are differing opinions on whether they simply have a right to notice of the initial petition and notice of hearing, or if they are now ongoing interveners in the case that would continue to get notice of everything. Summons. There is a statutory form for the summons, which is also in your packet, but is also in the statute. And the summons is required to give the disabled adult or alleged disabled adult all sorts of notice about their rights. They have a right to a jury. They have a right to an additional medical report. I don't know if I can say them all off the top of my head.
They have a right to close the hearing. They can request an independent medical evaluation. They can call witnesses.
Right.
But-
So you need to make sure you don't just use your standard summons form, but that you actually pull the guardianship summons form from the statute if you're going to do this type of work. And we've already talked about it has to be 14 days prior to the hearing. And then once you file, the court is going to appoint a guardian ad litem.
The way that I have worked it is that I will file the petition, then when I find out who the guardian ad litem is, coordinate the hearing schedule with them, and you need the hearing date on your summons. So just logically, then, the first thing to do, file the petition, get who the guardian ad litem is, coordinate the hearing date, put it on the summons, and serve the petition.
And so many of you may have served, even if you don't do guardianship work, have served as guardian ad litem. Guardian ad litem is required to go out and give a notice of rights to the individual to tell them all the things we just talked about, that they can have a jury trial and an independent medical evaluation, and they have a right to cross-examine witnesses. Guardian ad litem also gets to be the court's eyes and ears. The judge can't go to the nursing home or the hospital to visit the individual. And so their role is really to determine what's in this individual's best interest. And I always say to my clients, what's in their best interest may not be what they want, right? So the guardian ad litem is in that position of trying to determine whether, if they're objecting to the guardianship, whether they maybe still need one anyway. And if that's the case, then the guardian ad litem is likely reporting back to the court and requesting that the individual also have a court-appointed attorney. So you can end up in a case where you have the petitioner's attorney, you can have the guardian ad litem who's talking about what's in the individual's best interest, and then you can have an attorney that's court-appointed to actually fight the guardianship on behalf of the objecting individual.
The statute does provide that a guardian ad litem may not be necessary if the court finds that they don't need that in order to reach an informed decision on a petition. But I find routinely the court would like to have it, and it would have to be an unusual case that you would have where you wouldn't need the guardian ad litem.
So I do guardianships for Swan Special Care Center, individuals who are significantly developmentally and physically disabled. And on occasion, the court will waive a guardian ad litem if it is a family member that is seeking guardianship. Mom needs guardianship. There's no question that a guardian is needed. Sometimes the court will then waive that, but generally there is a guardian ad litem appointed. The guardian ad litem, the thing to remember, if you are appointed as GAL, you must prepare a written report, and our judges generally won't enter the order for guardianship until the written guardian ad litem report is received. So if you're appointed as GAL, please be prepared to file your report.
The court, on the day of the hearing, will usually inquire of the respondent, and you don't always know what their position is going to be. Even though you might believe that they may not raise an objection, they could still raise an objection there. The guardian ad litem will usually tell them about all their rights and find out what their position is. And you can usually find out from the guardian ad litem what that is. You know, you may have a copy of the written report, or they can tell you. And so you'll know what to expect with that. As far as having an appointed attorney, that can be expensive, and it may be a cost for which the petitioner is responsible. However, dismissing the guardianship can be only done with the approval of the court upon motion. So I think that someone should expect that if they initiate a guardianship and it gives clear indications of a need for the guardianship, that you probably won't be able to get into it and then try to dismiss it if it becomes contested. Sometimes it's possible to work things out. You know, it may be that a person would be willing and able to do a power of attorney after all. It's hard to say.
And sometimes the objection is really about who the guardian, who is requesting to be guardian versus the need for a guardian. So I like my daughter, but I don't like my son. And so sometimes you can get it negotiated because you simply just need to spend some time as lawyers talking to the individual and finding out what it is that they're really objecting to. So the hearing is set out by statute as well. As we said, the respondent's entitled to counsel and a jury to present evidence. The hearing can be closed to the public upon request, and our judges pretty routinely just close guardianship hearings. And they're willing to do that if the individual requests it. And then the respondent is supposed to be present at the hearing, but there are exceptions to that.
I think that sometimes this would put an undue burden on the respondent, but I think that this is an issue that I always discuss with the guardian ad litem to see what their opinion is about it. And other things being equal, an effort should be made to have that person there. And if the court believes that they should be present and they're not present, you won't be finishing up your guardianship that day.
There's also a provision in the statute where the court can actually go to the individual. And I have had that happen once where somebody was at the pavilion and we actually picked up and went over to the pavilion for court. That's pretty rare, and I can't imagine in these fiscal times that we'd be able to talk the court into doing it, but maybe we could. And this is just more about the hearing process. Something to note that is if the hearing is contested, the doctor is required by statute to appear and testify. You can't just file your medical report unless their presence is waived. So that's something the guardian ad litem or the court-appointed attorney needs to work out with the respondent, because you need to know whether or not you're subpoenaing a doctor before you get there.
I've gotten by with an evidence deposition, but it's not cheap.
Yeah, right. And so the court really just looks at the ability of the individual with respect to their physical functioning and intellectual functioning, whether or not they're able to make decisions, whether or not their living arrangements are adequate and appropriate, and just how they're doing in the community, and if they're able to continue to make decisions without somebody being appointed to make them for them. I always tell my clients there is a difference between making bad decisions and being unable to make decisions. I may choose this winter to run to my mailbox without my shoes on, and it might be cold, and it might be a stupid decision, but I'm competent to make that decision. The difference is the 90-year-old lady who's standing out in her sidewalk without her shoes on, and it's 30 degrees out, and she doesn't realize what she's doing. And so you really have to determine whether it's a choice to do something foolish, or they really are unable to understand the decision they're making.
Sometimes pictures will be persuasive evidence if part of the problem is the condition where the person lives, and that's sort of a product of the difficulty that they have with managing things. Anecdotal evidence from people that have heard and observed different issues that have arisen as a result of problems with decision-making capacity. You have to bear the responsibility of meeting the burden of proof, and it says clear and convincing evidence. So,
right. So there are some other issues that happen within the guardianship proceeding. First of all, we've talked a little bit about families' right to intervene. So it may be that you're proceeding along with, daughter, and then son decides to get involved. They can file a petition to intervene. They can be heard at hearing usually, even if they don't file a petition to intervene. And they have the right to file a petition and say they ought to be the guardian. So you need to be prepared for whatever your family dynamic is. Sterilization of the ward, you can file a separate petition and request the authority to have that done. There's a provision in the statute for that.
that takes special findings. I think in our office, we have just gotten our first case like that. And usually it has to do with the need for it. It's going to need to be necessary for some type of medical reason or because of the circumstances and what's going on there. And you have a heavy burden to meet to show that.
Sale of a house, you actually have to file a separate petition for the sale of the ward's house once you have a guardianship established. And so you'll need to look at the statute if you're going to be selling a house. The statute has recently changed with respect to estate planning, and so you need a doctor to certify that the ward is capable of estate planning, and then you need to file a petition for leave to estate plan, and so you need to keep that in mind. If you're going to have somebody who has some means and they want to change their estate plan once there's a guardianship in place. We talked a little bit about residential placement. I don't know if you want to.
In some cases, the court will consider entering an order for residential placement, even if that is not going to be immediately, if circumstances are such that it's likely to be needed upon short notice, and then require notice to the court and to the guardian ad litem in case there would be some issue concerning that. Another miscellaneous issue that I've considered is that if you're talking about a husband and a wife, sometimes there will be issues concerning possible transfers of assets and income to take advantage of anti-spousal impoverishment provisions in Medicaid. That's something that you would need to ask the court for authority to do and probably need to explain what it is you're doing and why you're doing it.
Right. And suspension of driver's license, we talked about. I didn't include it, but your FOID card as well. I don't think you'd want leave for somebody who has a guardian to continue to have their FOID card, but you can make that determination for yourself, I guess, with your clients. And then you can file orders of protection through the guardianship proceeding. So if somebody is being physically or mentally abused, you can, as guardian, you can move forward with an order of protection, and that does happen on occasion. So after the hearing, you get an order entered, and then what? And so your order needs to specify whether you have authority for residential placement, whether it's limited or plenary, whether it's temporary or permanent. Temporaries, remember, only good for 60 days.
Temporary orders also will have to have enumerated powers for the guardian. And although I haven't had too many cases like that since there's been this adjustment in the statute, I think that it's reasonable that the powers that you are going to be listing are the ones that you need with some exigency. So if there is something that you need to do right away as part of the temporary guardianship, then you would want to have authority to do that listed in your order.
And I tend to list all the authority in both temporary and permanent orders anyway, and you've got copies. The form order that you have is one that I've worked with Office of State Guardian on, so it has some additional language that you might not normally use, but it's language that they like to have in their orders, and so I now just include that in my orders because it's easier to do that. Your guardian has to file an oath and bond. The bond is 1.5 times the value of the estate. And if they have a insurance bond, and it's
2.5 times, and the usual rule would be you need at least 2 sureties if you're going to use personal sureties. There are some circumstances with a small estate, or if the estate is just to manage some kind of public benefits, where the court may waive the requirement, but if they do, even if somebody doesn't sign a paper, there is an implied bond in the amount that they would have had to do.
Although I've tried to enforce on bonds, and it's not particularly easy to do, so if depends on which side of it you're on, but don't think that is going to be the thing that saves your client because there's a bond in place. They are not easy to enforce on, at least that's been my experience. You also need a notice of right to seek discharge. Again, that's a statutory form, it's in your packet, but it's just a statement that the judge signs so that the ward knows that they have the right to come back to court if there's a change in circumstance or if they want the guardianship terminated. Generally, they would have to show through a medical report that they no longer need a guardian, and they've got to show clear and convincing evidence that they no longer need the guardianship.
It's not clear whose responsibility it is to deliver that form. Usually the guardian ad litem would do it, but it's probably a good idea to have one handy just in case they don't remember to have one handy.
Yeah, if you're petitioning, you should bring one. So then you're required to report as the guardian. You have to file an inventory if you're guardian of the estate within 60 days. Report to the court sometimes annually, no less than every 3 years, and that'll be part of your order. So the court will tell you how frequently you have to report. And a guardian of the estate can get themselves in a whole lot of trouble if they don't keep track of the records. So it's important to send your client follow-up and make sure they understand the amount of record keeping they need to do.
What is that whole lot of trouble? Looking at guarding ad litem in a really confusing way.
Yeah. Well, I mean, they could forfeit their bond.
They can be brought to court on a citation.
Yep, there's a contempt
Uh,
citation.
And they can be required to appear and answer questions, and the court would have authority at a citation hearing to enter orders with respect to property. For instance, if somebody did anything that they shouldn't have done, like transferred a house or something like that, the court would have the authority to reach that property and get all the information that's necessary to make some restitution.
I would also say that our standards for reporting have become increasingly stringent over the last 5 to 10 years. And so it's really important, particularly now the court enters a separate order if you don't include the language in your guardianship order with respect to reporting, so people know what is required of them, so they can be held to that standard. And there is an expectation of regular reporting. The judges now track it, so if you don't file your report, your client and you are gonna get a letter that says, you've got 60 days to get this on file, and if you don't, then I'm gonna issue a citation. So you need to understand that reporting is now going to be monitored at a level that perhaps years ago it was not.
At a minimum, the guardian needs to know that they keep their money separate, that they keep records about what they do, hopefully in some organized fashion so that they can present this report. Ramona?
In a pro bono referral setting, presumably you would be making these referrals as a limited scope sort of thing, where you do this petition and you're not on the hook for the rest of your life to report, correct?
I continue to report for my pro bono people. So I send them the forms, I remind them that they need to get their report on file. Usually they're not reporting for the estate, they're just reporting for person, because I wouldn't be involved if there was money involved, right, as a pro bono attorney. So it's, can you get me an updated doctor's report that says how your daughter is doing, or whatever it may be. You can also withdraw. So the other thing you could do is get out, and then it becomes their responsibility. But it's important for them to know that they've got this ongoing responsibility.
But I think what Ramona brings up is a good point. If you have the courage to take a pro bono guardianship, it's not a life sentence.
Right. Unless you choose for it to be. And then here's just a list of all of the forms that you all received in the packet. And then do you have any questions? And I think we're right on time.
What is the guardian up for as far as if the ward is, crazy, debauched, gambling, making debts? What is the guardian up for? What do they face?
So the guardian is responsible to manage the ward's money to the best of their ability, reasonable person standard, to take care of the ward's finances. They are not responsible for paying their own money to take care of the ward's debts. Is that your question?
That is my question. So they're not responsible. What if, as a guardian, they sign a lease?
No. Yeah, then that becomes more complicated.
That becomes their problem.
What the other issue that becomes harder is nursing homes will often require the guardians to sign as individuals, not as guardians. I always tell my clients they have to sign as the guardian, so that it's clear that the nursing home has a right to the ward's funds, but not to your funds personally. And I've had some nursing homes refuse to take people, and then the guardian's got to make a decision about where it is
But
they
as a
want.
lease, if you sign a guardian as a lease, as you sign, I am guardian for X, and you sign a lease, what is your liability?
Well, your liability is to spend the ward's funds on that lease, right? So you don't get to not pay the ward's funds.
I think that there is an issue there that you can see that there would be unhappy creditors because there's going to be some preference shown to certain creditors. And So I suppose sometimes they try to make arguments like that. But usually, in the cases where there would be some kind of claim against somebody in their fiduciary capacity, their duty is to exercise due care with respect to the best interests of the ward.
Right.
And does that mean that you have to pay everybody everything, even if they don't have enough money to pay everybody everything? I don't think so.
Right. But you can't enter into a lease that they can't afford to pay either.
Right, if you're gonna sign a lease over at Trump Towers and you know they can't pay for it, I wouldn't expect to be shielded by your expectation that you're limited to their income.
Anybody else? Yeah, Jim?
Can a state guardian settle a personal injury claim without court approval?
Not in Champaign County. At least I have. Have you been able to get that
Well,
done?
no, I saw your list of, obviously, if you want to sell the house, you gotta go to court and
Yeah.
various other things, but I didn't know you was talking about plenary duties or rights. What does that mean exactly? What can a
Well, so the statute says that they do have the right to step in on behalf of the ward, and whatever claims the ward has, that the guardian has the ability to prosecute those claims and to move forward. But I don't think you could get a personal injury settlement approved in Champaign County without the court approving.
I think we've got a local rule that requires,
Yeah,
Yeah, there is specifically a local rule, even when, it takes some, it does take some extra English, no doubt about it. I've had one approved just in the last 6 months or so, only to have that associate judge come back and say, the circuit who supervises me, I'm gonna go back and do this again, so.
Anyway, I'm dealing with a Chicago lawyer who says we don't need to do that.
well, and our local rules actually have kind of a list of things that you're supposed to plead, I think, or at least the judge is supposed to review prior to approving it, because I've had some Chicago lawyers where I've sent them a copy of our local rule to remind them of that.